Good morning, everyone. Thank you for joining us for this Illinois School District FOIA webinar. My name is Mandy Kalinskis, and I'm the marketing coordinator here at Datamation. It is my pleasure to introduce our first speaker, who is Christine Walzak, a senior associate at Tressler LLP.
Thank you, everyone, for being here today. Just a little bit about myself before we begin. I'm an associate at Tressler LLP, and I've been advising public bodies on FOIA for the past 6 years. I've actually served as a FOIA officer for 3 years. I'm one of the few people who actually enjoys FOIA. But today, as we go through these slides, I'm going to try and give you some helpful tips on FOIA so that it can make your lives a little bit easier. Right on the screen right now is an agenda of the topics that we're going to be covering today. My presentation is going to go over the first 4 topics, and then Jim's going to go over the last topic. The items that I'll be discussing today is giving you a brief overview of the purpose of FOIA and why we have this statute. Then some recent changes in FOIA, primarily a recent case that does affect school districts, and then the types of FOIA requests that public bodies receive and why they need to respond to FOIA requests. And then finally, we're going to go over the proper procedure for denying a request. So the reason why we have FOIA is to promote a transparent government. And the way that our legislator has said that we can promote a transparent government is by providing the public with access to public records. The statute defines what is considered a public record, and you may be surprised at how broad this definition is. A public record does not just include, a document that's tangible, but it also includes emails, texts, recordings. And essentially, in order to be considered a public record, it must pertain to the transaction of public business and either be prepared by, used for, or in the possession of a public body. So as you can see by that definition, it's very broad, and it includes essentially everything. As I'm sure most of our listeners already know, FOIA requires every public body to designate one or more officials as their public FOIA officer. To be a FOIA officer, you don't just need that designation, you also need to go through FOIA training. We've provided a link on the slide that directs you to that training. So if you haven't done it yet, you can click on that link. And this is a yearly training. So it's not just like the OMA training where you do it once and you're good. This you have to keep up on it every year if you want to remain a FOIA officer. I've done the training before because I've been a FOIA officer for 3 years. I know Jim said he has done it too, and it really depends on how much you want to get out of this training. It took me, I'd say, about the first time I did it, 3 hours to get through it because there's lengthy fact patterns and the answers. I wanted to read through all of the answers because there's a lot of questions in there, but I wanted to get as much out of it as I could. You probably, if you wanted to go through it quickly, you could maybe get through it in an hour and a half, but it's very helpful. They update the training every year to like any new changes in FOIA. So it's really good. It's a good resource to have too. Even if like you've done it already, sometimes you might want to go through it again to update yourself on FOIA. In 2019, there were 13 binding PAC opinions. There are also several appellate court decisions relating to FOIA. We've listed a few of these cases on the slide, but the one in particular, which I mentioned earlier today that relates to school districts, is Taponi versus Illinois Student Assistance Communication. In the case, the court held in favor of the public body, which was challenged for denying a FOIA request for the names of students who received MAP grants. So what the court ultimately ruled in this case was that the names of these students were exempt from disclosure, the names of the students who had received these grants. The next 3 slides that we're going to go through address the common issues and questions that have come up with a lot of clients that I've worked with regards to fulfilling FOIA requests. A common question that I get from clients is whether the text that a public official sends or receives during a public meeting on the official's personal electronic communications device would be FOIAble. The answer I always give to my clients when they ask a question like this is maybe, and it really depends on the facts of the situation. But what it really depends on is if the communication, like the text, it pertained to the transaction of public business. If that is the case, then it's most likely going to be FOIAble. I also get questions about requests for a commercial purpose. One of the nice things about commercial requests is that it gives the public body a longer time frame for responding to the request. So rather than your standard 5 business days, you get 21 business days. Now, a business day, just as a refresher, it does not include weekends and it does not include federal holidays. And I believe the PACS, the Public Access Counselor, their website has a list of what they can of the federal holidays. So if you aren't sure whether that's considered a day in calculating the FOIA response, you can I think you can get it on their website, or it might actually be in the training. So if you do get a request that is for a commercial purpose, your response is going to have to be one of 4 things. You can either provide the requester with the records within that 21-day period. You can deny the request based on an applicable exemption. You can notify the requester that the request is unduly burdensome, which we're going to be discussing a little bit later in this presentation, and ask the requester to narrow their request. Or you can provide the requester with an estimate of the amount of time that you're going to need to respond to that request, and any costs that you're going to incur in order to respond. If the response is a request that contains exempt information and non-exempt information, the public body, the school district, you're still going to need to provide a copy of that record. You can't just wholly deny it, but the record that you're going to provide will need to redact any exempt information. A lot of times public bodies think, oh, this contains exempt information, so I don't have to give it. No, that's not the case here. You just need to redact or black out any information that is considered exempt. And then the next part of this slide talks about being able to charge fees. Now, while a public body is allowed to charge fees for providing copies of records, the fee structure under the FOIA statute, it's very restrictive. So a public body, you can't charge anything for the first 50 pages. So no matter who the requester is or what it's for, you can't charge for the first 50 pages. And then if you get past that threshold, you can only charge 15 cents per page. So there is a lot of limitation there. And some public bodies, they don't charge at all. But if a lot of times, if you want, the most you can charge would be 15 cents. There's also certain types of exceptions for certain requesters where this fee structure doesn't apply, like the news media. So there's sometimes where, because of who the requester is, or if they request a waiver for a certain reason, you may not be able to charge them. So if this comes up, that's a good question to either contact your attorney, or you can sometimes call the Public Access Counselor, their office, and ask them if you're allowed to charge. So last part of my presentation is going to go through the denial process. And I think this is probably the part of the presentation that a lot of you are the most interested in, because we're going to go through some common exemptions. We're going to go through what an unduly burdensome request is, and then a voluminous request is, what you need to include in your denial letter, and then the appeal process. So there's tons of exemptions that are set forth in FOIA. The sections that set forth these exemptions are sections 7 and 7.5. I wanted to give you those references just because I'm not going to be going through all of them, but if you look, you can go to the statute and you'll see this laundry list of exemptions that you might apply. But what we've put in these next three slides, what I've included in here are the most common exemptions I see that come up with my clients, and ones that relate to school districts. So hopefully this will be a good source, a good tool that you guys can reference back to when you have questions about things. So one that comes up a lot is what is private information. So if there's information in a record that's private, you can redact that. Now, what is private information? Well, FOIA defines private information, or I guess gives some examples of what private information is, as social security numbers, home telephone numbers, driver's license numbers, and signatures. Now, that's just a few. That's not exhaustive. That exemption is 7.1b. And what we're going to talk about later here is when you are going to assert an exemption, you do need to reference the statutory section. So 7.1b is if you're going to exempt something as private information. Another exemption that's common is personal information. This is under section 7.1c, and an example of personal information would be birth dates. Educational information and academic information is sometimes exempt from disclosure as well, and examples of these types of information that that are exempt under the statute are test questions, scoring keys, and certain course materials. Section 7(1)(m) of FOIA exempts privileged attorney-client communications, or in other words, it exempts records or information that reveal confidences or contain legal advice. A lot of times, the questions that I get with regards to this type of exemption is when a school district or a public body gets a request for invoices that are from their attorney. Courts have normally construed this exemption very limited. They are not going to allow you to exempt a lot of information. With this, in most cases, you can't state that just because it's an attorney invoice that it's wholly exempt. That's not going to fly with the PAC and with courts. What you're going to need to do is, and this is a good thing to, I guess, go to your attorneys for, because it's kind of a judgment call, but you can only redact the information in those invoices that disclose any private attorney-client communication. So the amounts, you're not going to be able to redact that, but if there's anything that is in those invoices that contain some type of legal advice, then you will be able to redact that. A lot of times, municipal attorneys or school district attorneys, they might phrase their invoices because they know about this, to not include any legal advice, just so that it makes it easier on the public body if they get a FOIA request like that. Another exemption that's listed in this slide is job applications. So sometimes public bodies will get a request for job applications relating to a certain position. And the question that we get is, well, do we have to disclose those applications? Yes and no. You have to disclose the application of the applicant who actually was hired. For those applicants who were not hired, those are considered exempt. Other exemptions include the names and addresses of grant scholarship applicants, and then records relating to a public body's adjudication of employment grievances or disciplinary cases, except for the final outcome of the cases in which the discipline is imposed. So how does a school district meet its burden if it's going to withhold a record or if it's going to redact information from a record? This is a nice list here of kind of explaining what you need to do to make sure that you meet that burden. One of the most important things, and we're going to talk about this, I think, in 2 slides, is to make sure that you conduct a reasonable search for the records that are being requested. And we're going to define what a reasonable search is. But you want to ask yourself, what search terms did I use if I was asked for a bunch of emails or emails of a particular person? Which search terms did I use? And make sure you document that, because that could come up if you deny something as being unduly burdensome because there were too many responsive records. And then where'd you look for those records? You also have to make sure that you include the reason that you're exempting or withholding certain information. And like I said before, list that exemption, that statutory section, and then explain why you're using that exemption and why that applies in this particular situation. So the legislator has provided public bodies with a tool that they can use in situations where the number of records that are being requested is so many and it's going to cost the public body so much that the time and resource, that the burden on them is going to be so great that they can deny the request. So this is an unduly burdensome request, and it's a nice tool that public bodies are given when they get a request that's overwhelming and it's going to cost thousands of dollars or have so much time. It's going to request multiple people to respond to the request. They can assert that it's an unduly burdensome request and deny it. But before they can make that assertion, they need to contact the requester and ask them to reduce their request to manageable proportions. A pointer that I give my clients is that when you want to argue that a request is unduly burdensome, is that you include in your letter, because you do, even if you're going to deny a request, you're going to have to respond, give them a written response. You want to include in your letter the number of records that the public body would need to go through in order to respond. And then you also want to tell them the amount of hours and the amount of resources it's going to take you as public body to respond to that request. So those are important things to include in your letter to show and to demonstrate why this is going to be such a burden on the public body. Because if they appeal you, that's what the PACS or the court is going to look at is, okay, what is your reasoning for that? Another tool that the legislator has given public bodies is by creating a category of a request called a voluminous request. Essentially, the advantage of, and we've defined what a voluminous, or we put in this slide what a voluminous request is considered. So you can just read that, and that's how they define a voluminous request. The advantage of treating a request as a voluminous request, if you get one, is that you're allowed to charge fees and assess costs if the requester does not amend their request to make it no longer voluminous. Because as we've talked about earlier, there's only certain this legislator was pretty limited on when you can charge fees, and this is a great opportunity if the public body wants to charge fees if they treat it as a voluminous request. But you got to make sure it's voluminous. You can't just say it's voluminous. You got to make sure it meets some of these requirements that we've listed in this slide. So what does it mean for a public body to conduct a reasonable search? Essentially, the public body needs to make a good faith effort. That seems pretty ambiguous, but that's what the PAC has said, is you have to make a good faith effort. And a way to demonstrate that you've made a good faith effort is, like I said before, document what you did to look for these records. If you're gonna say that you don't have the records, then you don't have to include in your letter, but at least have some type of documentation showing what did I do to search for these records? Who did I ask? Who did I contact? Where did I look for these records? If there were search terms that I needed to get emails, what search terms did I use? Those types of things you want to make sure that you have. So if you're asked later down the line, well, what did you do to conduct this search that you weren't able to find anything? Well, this is what I did. Okay. And the same thing when you do a search for records and you get so many that are responsive that it becomes unduly burdensome. Okay, well, were you able to narrow this request, or why were there so many records that were responsive? Sometimes that's what the requester asked for, but other times if the requester asks, has a request that's very broad and requires you to kind of do some investigation into what the responsive records are. If your search you could have done a more narrow search to yield less records that were responsive, that's what they're going to look at, is whether it was a reasonable search or not. If you end up deciding that you're going to deny the request, or and a denial is you can deny a request by redacting certain portions of responsive records, or just by not giving the records. So, you're going to have to follow, or you're going to have to include the things that we have in this slide in your letter if you do either of those things when you respond. So you're going to have to include the basis for your denial with the specific exemptions, meaning you're going to have to list the statutory section of FOIA, whatever 7.1 if it's for privileged attorney-client communications, that's the reason for your exemption. List that section, include the language from the statute, and then you got to explain why that applies in this situation. You also have to include the names and the titles of the positions of the people who made that decision. So if you're the FOIA officer, include your contact information and your name, and make sure you let that request know this is the person who decided that we're denying your request. You also have to include an explanation of the requester's right to seek review of your decision by the public access counselor. So you have to tell them, all right, well, if you disagree with why we're denying your request, you can go to the public access counselor and tell them that you disagree. You have to provide the contact information for that public access counselor's office, which if you go on their website, they have a model letter, I believe, which has all of this information that you need to include. And then you also have to inform the requester of the right to judicial review under FOIA. So I've referred to the public access counselor, or the PAC, throughout this presentation, and this slide here kind of just tells you what exactly this office does, this public access counselor's office does. And in the past, I've worked with them. They are very helpful. People are surprised, or they don't even know that the public access counselor is a great educational resource on FOIA. If you don't have, a legal counsel you can call with every question, a lot of times I say, call the public access counselor. That's their job, is to educate you. And depending on who you get, it could be very helpful. A lot of times they're not going to give you a direct answer to your question, but they will direct you to resources that you could use to answer your question. So that, don't be afraid to call them. You can call them anonymously, and you don't have to say, I'm from this, school district. Just say, I'm a FOIA officer and we got a request like this and I'm just not sure how to respond to it, or can I charge fees for this? And they might give you an answer right off the bat, or they might say, well, here's a PAC opinion that you can read that will help you. But it's a good resource that a lot of school districts or public bodies don't realize or they forget about. So I just wanted to make sure that I gave them that shout out there. So this last slide here, it is a nice little chart that kind of explains to you the request for review process. So as I stated earlier in this presentation, if the requester is not happy with you denying their request, they don't think that it was done right, or they think that they're entitled to these records, they can file a request for review with the public access counselor's office. And the outcome of filing that request for review is the PAC can issue a binding opinion, or they can issue a non-binding opinion. A non-binding opinion, it can't be the base. If a non-binding opinion is issued, it's usually better for the public body, because that means that it cannot be the basis for a lawsuit against a public body, and it's not going to be subject to review again. Now, if a binding opinion is issued, and there aren't that many binding opinions that get issued each year, as we discussed at the beginning of this presentation, there were only 13 that came out in 2019. But as you can see, if there is a binding opinion, it's a big deal. So if a binding opinion comes out from the public access counselor's office, that means that it can be appealed, and it could also be the basis for litigation.
Okay, thank you, Christine. All right, we know that was a lot, so we're going to just take a moment to look and see if you guys have put any questions into our question section here. All right, I do have one. So Christine, I'm going to ask this for you. The question is, are there any legal ramifications, issues, problems if we do not respond to a FOIA request? So I'm going to let you take that one.
Okay, so yes, there are. That's the answer, the short answer. So except for requests for commercial purposes, a public body, as a refresher, needs to respond to a FOIA request within 5 business days. Now, if a school district does not respond to a FOIA request at all within that time frame, or at all, it's going to be treated as a denial. And you don't want your request or your response to be treated as a denial, because you're going to lose some different tools, or you're not going to be able to charge copying fees if you would have been able to in the past, and you won't be able to treat that request as unduly burdensome if it is. So if the request is unduly burdensome, if you don't respond within at all, or within that 5-day period, you're going to lose that right to assert that it's an unduly burdensome request, which is a big thing to lose. Also, if a public body denies a request, the requester may file a request for review with the PAC, like we just discussed in that last slide, and or they can file a suit for injunctive or declaratory relief.
Okay, thanks, Christine. For right now, I am going to turn this over to our second speaker, which is Jim Collins, the principal of Datamation Imaging Services.
Thanks, Mandy. We're going to change directions here a little bit, and I'm going to talk about how imaging can be a valuable tool in helping you meet FOIA requests and other requests in general. My presentation only goes about 5 or 8 minutes, so please hang in there. I know we all have busy schedules. Traditionally, when we've worked with school districts, and we've worked with over 60 of them, we've done student files, board minutes, personnel files, and we've imaged these and gotten rid of the originals for privacy and access and things like that. But over the last 8 years, I've seen kind of a trend where the business office, specifically maybe somebody in the accounts payable area, is putting a scanner in there. And let's say they're in Skyward paying a bill. They put the invoice in the scanner, hit a button, and they capture that invoice. Okay, invoice, expenses, those things they do come under FOIA. So somebody can ask you for an invoice. And I will show you an example of that, even though you need to keep these things just 7 years. On the screen, you'll see a Tyler Infinite Vision school management system. And this is a vendor screen within that software. And I'm assuming here that somebody put in a FOIA request. I want to see the Datamation invoice from December of 2019. So we wrote a little integration here with the blue button in the top, and all you do is hit that. And I'm literally going online to a cloud-based ECM system, and I'm doing a search of invoices for Datamation. And it pulls up a result list of these, and here's the one from December, and I'm just going to simply double click on it and pull up that invoice. And again, like I said, this is all coming from the cloud. There's that invoice, and again, at this point, I can view it, print it, email it, whatever I need to do. But what I'm going to do now is email this to the requester, and basically just pull that invoice up. And what's going to do is it's going to take that invoice, create a PDF of it, and open up my email client with an email. And now all I have to do is put the requester's email address in there and an explanation, and I fulfilled that fulfilled that FOIA request. In summary, we do this for a lot of school districts, and the bottom line is this can reduce your time to retrieve something for a FOIA request or a general request to a minute or less. We scanned 70 boxes for a school district on the North Shore last year, and it was taking them 4 hours to find a file. And after we scanned them, they were finding these things in under a minute or two. So again, time is money. Okay, moving on. One of the biggest things with school districts is not only the access and management of these records, but how long do I have to retain them? All right. Last April in 2019, I did a webinar on document retention. It was a very popular webinar. We had over 50 people on it because it's just a big challenge. And what I can say about this is you really need to review your retention schedule on a regular basis. If you haven't done it in, say, 5 years, you probably need to start from scratch and do it over again because the retention guidelines change on a regular basis. Okay. So, and you're also probably keeping things longer that you need to keep. There's 4 things for best practice for document retention. Number 1, your retention guidelines must be in writing. Number 2, you have to have them reviewed by your legal counsel. Number 3, you have to have them approved by the board. And the last thing is you have to have an application on file that's a timely application that's approved by the State Records Archive Unit in the Secretary of State's office. Again, the same place where the PAC come from. The person I deal with the state is a gentleman named Steve Khaleesi, and many of you on this webinar probably already dealt with him. His office is out of West Chicago, and by getting a hold of him, he can come in and start the process of organizing your records, setting the retention requirements, and getting an application rolling with the state so that they can come back and give you permission to retain your records, and the ones you've retained you can destroy. All right, from the white paper, this is a snippet of records that come under the guise of the superintendent. And the superintendent is responsible obviously for board minutes, policies and procedures, as well as of a lot of other administrative type documents. But so you see there's stuff in there that you have to keep permanently. And FOIA requests, you see you only have to keep 2 years. What's interesting about this is I think back in like 2013 and before, you had to keep FOIA requests, a file of those for over 5 years. You can see that they're getting a little more liberal with some of the retention requirements. Student records may come under the curriculum area or a records area. Again, you've got health records and permanent records that you need to keep 60 years or when the student becomes 78 years old. Okay, that's a long time to keep something. And again, having a system to do this helps. Again, working with districts, every district kind of handles it a little different, but I will be honest, it's more the exception than the rule when the district kind of keeps the permanent and health records separate from the CUME file and the temporary records. So again, if we scan records or work with a school district, we take this into account. In wrapping up, I'd like to just talk briefly about 2 solutions that are directed towards school districts. One's called Scrib Order and one's called Scan to Zero. The Scrib Order is a system from a company called Scribble Software. They're on the East Coast in North Carolina. It's a free service, and they literally come in and write web pages that look exactly like your web pages that basically create a portal where all FOIA and general requests can go through this central portal. okay? And when somebody goes online, it verifies their identity. It goes through the FERPA process to do that, and you can charge for these requests. Not all requests, obviously FOIA requests you can't charge for unless they're burdensome, but there are some that you can charge for and generate income. And let me just kind of show you an example, a real life example of what's of a district locally that's doing this. All right, this is a district in Illinois, and you can see here that the Scribble software, they put this online request link right on their website. Now you're actually on the Scribble's website, okay? And you can see here, the top option is a student looking to order a transcript, okay? The second one is a former student or an alumni that wants to order a student file or a transcript. The third one is a college, corporation, or a government agency requesting graduation or verification of a student record. And the last one is an attorney or a legal request. Again, once you click those, it takes you through the process to perform the request. So again, that is a really good tool to track and centralize all your requests, as well as it can generate income for requests that are chargeable. Scan to Zero is another service we perform where we literally come in, pick up your 300 boxes of records, and immediately clear out space. We did one for a company on the up in the Zion area last year, and they, over the summer, their buildings and grounds people made it into a new classroom. So that's a good example of clearing that stuff out. But what we do is we take all these boxes, we organize them and classify them, and then we say, hey, let's work on a set number of scanning 5 or 10 a month. We destroy records with your permission that have exceeded their retention period, and anything that's close to meeting the retention period, we'll store them until we can trash them. Now, this is what I give you back. It's a record summary. So if you have 300 boxes, you're going to get a spreadsheet with 300 rows. Now, if you look at the first row on here, these are special ed files that you need to keep through the year 2027 or longer, because special ed files have typically a 5-year retention. We're going to probably suggest you scan these. In the second row, we have special ed files for students that withdrew in the year 2002. We're going to recommend you destroy these because you don't need to keep them past 2007. And then if you look at the fifth line down, there are accounts payable files from 2013, which come under the business office project. I would recommend putting these in my warehouse and storing them till January, to which we know they're all 7+ years old, at which point we can shred them. So you get the gist of it. So for every 100 boxes we go through, there's probably only about 50 that need to be scanned, and the rest can be either destroyed or stored for a period of time. Now, what do you have to do next? In summary, you have to ensure that your FOIA officers have completed the training in the last 12 months. I went through the training in August, took me about 3 hours. I think if you've done it once or twice, you could probably do it in a couple hours. Not hard, but it's about 106 slides and it has a lot of information in it, a lot of legalese in there. You need to make sure that your FOIA officer contact information is easy to find on your district website. This is not always the case, and I highly recommend you do this. I would call Christine if you have questions in regard to FOIA. She's an expert on it, has a lot of experience in it, as you can tell. And if you want to talk about document imaging, scanners, things like that, and tools for FOIA, I'm here to help you with that. In summary, we're going to record this webinar. We are recording it, and we're going to get it emailed out to you probably later today or tomorrow, so there's a link to it. Make sure you grab the handout white paper that's on the handout section of this. And we are in the process of planning another webinar, maybe in 2 or 3 months, on the SOPA, which is a brand new Student Online Personal Protection Act law that your districts really need to bone up on, because I think this thing's enforceable in 2021. So anyway, if there's any last questions, we'll answer them. We appreciate your attendance today.
Thanks, everyone. We're going to stop sharing the screen, but we are going to stay here so we can go through the questions and take a look at them. The first one I have is actually for Jim. The question is, are there any legal ramifications to scanning your documents using imaging instead of keeping the paper?
There are 3 litmus test rules that were established years ago when people would use microfilm or digital technology as the main medium for their records. The first is that it has to accurately represent the original. The second rule, you have to scan as in the regular course of business. And the third is you have to have these backed up on another media someplace. Now, if you do that, the images as well as the backups are then considered the originals. Now, this is a federal guideline, digital images rarely, if ever, get disputed. But you should always check with your legal counsel on this and get further input from them on that. But all these districts and organizations are now scanning all the records and using those as the working copies as well as the original in real life.
Okay, that's great. I have another question. Let's see. Okay, so this question is going to be for Christine since it's about FOIA. So the question is, does the count for number of days to reply to a FOIA request start the day that the request is received or the day after?
That's a really great question, and that's actually one of the first things I had looked up when I became a FOIA officer. Good news for you, good news for the public bodies, it actually starts the day after you receive the request. So if you receive a request on a Monday, you start counting, that first day starts on that Tuesday.
Okay, I'm going to pop up one more screen just as a thank you, and I want to make sure everybody sees Jim and Christine's contact information just so you can jot it down if you need it. Thank you for joining us again, and we look forward to seeing you guys for the SOPA webinar, and have a good rest of your day.